from your excuse.
A woman alone in a city she doesn't call home, a probation violation, and one last shot at redemption. When Ollie Kelly entered that courtroom, she didn't ask for sympathy. She asked for a second chance. What the judge does next might just save her life or end her freedom.
Are you all ready to proceed on the motion? All right, court is calling 2025 CR 00123. I'm sorry, 1273W. I'll repeat that. 2025 CR 00123W, State versus Ali Jawana Kelly. Could I have parties announced?
Megan Galloway for the state.
Roberto Weiser, the defendant, ready to proceed, Your Honor.
And are you Miss Kelly? Are you the same Ollie Kelly who was placed on deferred adjudication in 2025 CR 0012773W for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on February 5th, 2025 for a period of 2 years? Is that you? All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Ollie Jawana Kelly, did then and there fail to report to the supervision officer as day for the months of March, April 2025.
Will you plead to that, true or not true? Okay. All right, did you understand by pleading true to that, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor. We are asking you to deny the state's motion, continue the defendant on community supervision, but to include an updated top evaluation mental health of ISP program.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up. You can lower your hand, state your name for the record. All right, why did you not report?
I've been homeless and I'm not from the San Antonio area, and I'm requesting for assistance with bus fare
All right, where are you from originally?
from Texas.
Sorry,
Beaumont.
so what brought you here?
Moved here. I worked here, lived here for a while, fell on hard time.
All right, and when you say you worked here, what were you doing here?
I worked at Jewelry Plaza, Conduit,
Doing what?
Jewelry Plaza housekeeping, Conduit Plaza as Verizon telemarketer.
All right, so did you come here for work? I mean, what's the reason why you came to San Antonio? Why not
I came here
somewhere else?
within this last year, so I'm falling on hard times.
No, I mean, did you come here by yourself?
Yes, myself.
All right, so you just came because there was a job here?
I just need
All right, do you have children? Age? And how old are you?
38.
And so is all of your family in Beaumont? All right, so how often have you been using before you were arrested?
I've been trying to get back into work.
No, you're not listening to my question. You're on deferred adjudication for possession of drugs.
Yeah, and since then, I've been doing everything that I possibly.
So before, I'm talking about before, how often had you been using?
Oh, before recreational.
Okay, here's the thing. I was not with you. So I don't know how often you were using. So that's what I'm trying to, I was not with you.
I'm really sure I wouldn't say that it was an everyday thing.
And what were you using?
Smoking weed.
And what else?
I guess you would call it methamphetamine.
No, I mean, I wouldn't call it anything. I wasn't with you. That's what I'm telling you. Here's the thing. You're on deferred adjudication. I could send you to the state jail facility for 2 years. So what I need you to do for me is answer the questions that I'm asking and be honest. Because it appears that the state and the defense want to continue on probation. When you're on probation, this is a contract with the court. I do not have to follow any of their recommendations. So I'm trying to figure out what's going on with you. And if you're going to be dishonest with me, that means that there's nothing I can do to help you. And maybe 2 years is what you need to open your eyes. I was not with you when you were using drugs. I don't know what your idea or your definition of recreational use is. Now that we've said that out the way, I'm going to pretend like I'm just now meeting you. And I've just sworn you in. So how often were you using?
During the week, like once a week, like
And what were you using?
marijuana and methamphetamine.
And when did you first start using meth?
2021.
And is all of your family in Beaumont or here? All right, I'm going to give you a choice. I can continue you, but if I continue you, you're going to have certain conditions. You're going to remain in custody until a TAP evaluation is completed. You're going to follow all of those recommendations of TAP. And I'm going to give you some more conditions that I see that the previous judge did not give you. So, or I can revoke you and I will sentence you to 1 year in the state jail facility. What do you prefer? All right. And probation, is that your recommendation? All right. The court will deny the motion, alternate amend conditions. And I'm sorry, they're wanting a mental health evaluation. Have you ever had any mental health issues? Have you ever been on medication for mental health? All right. The court will deny the motion, alternate amend conditions. There's going to be a TAP evaluation in custody. That's to see what drug issues you have. It's basically a resume for your drug use.
Judge, in speaking with Ms. Kelly briefly, she did say that she was getting some medication for anxiety to help her sleep, and she's dealing with a bit of depression. I would like to get that.
All right, there's to be a mental health evaluation in custody. There's going to be 120 sober meetings and 120 days upon release. How far did you go in school?
I graduated with honors cum laude.
Is this?
No, that was high school, and I did cosmetology.
All right, there's going to be 200 hours community service restitution. Those hours will be waived if you obtain some sort of trade school certificate or complete some higher level of education.
Massage therapy.
Sorry, what?
Massage therapy.
Okay. And there's to be weekly reporting upon release and proof of employment within 45 days of release, no employment as a home health care provider or with minors. And
On Netflix, they have that, it's a documentary on the guy that hid that treasure. Everybody's looking, I remember you always told me about that
Yeah.
a long time ago.
okay, have you seen that? Isn't that
Crazy.
it was crazy.
It was cool though. I mean,
We were watching it and we were like, what? And then there were parts where I'm like, oh, I don't need to see that.
right?
All right, let me see.
Judge, on this one, this is our first setting, right? And so I think it'll follow a speedy trial motion, should be dispositive.
Case.
Do we not recall who the bond company was, Judge? Do you recall?
All right, y'all are asking to reinstate the bond.
Actually, we're asking to set the bond, Judge, but state has agreed to reinstate it. However, at this point, we're just wanting her to get a bond so she can bond out.
You can't, I can't reinstate the bond unless the bondsman is in agreement to reinstating her bond.
I think they meant to reinstate the same amount that she was previously.
And what was the previous bond amount?
5,000, Judge.
All right, so it shows that she was late for court.
That's correct.
Court is calling 2025 CR 003690 State versus Mia Herrera. Can I have the parties announced for the record?
Andrew Harrison.
Leo Gonzalez for Mia Adela.
And are you Miss Herrera? Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record. All right, why were you late for court?
I had just found out that morning that I had court.
All right, and what are you asking the bond to be reinstated at, defense?
5,000, Judge, which is the original amount she made.
State, are you in agreement to the $5,000 bond? All right, the court will reinstate your bond at $5,000. Counsel, have you received all discovery in this case?
I know we have it, Your Honor. We were just hired a couple of days ago, so we're working on getting that taken care of.
All right, Ms. Ferguson, recall this case for June 9th. State on June 9th, you'll need to tender an offer, and then there will be a plea deadline date set immediately thereafter. All right, is there anything else?
No, Your Honor, that is all.
All right, Ms. Ferguson, make sure she has a reset form.
Yes, ma'am.
David Johnson.
Thank you.
A front door left open, a child crying for food, and a mother now in court facing the weight of her choices. In this gripping courtroom drama, justice meets heartbreak as a judge decides punishment or a final chance to become the mother these children need.
Because the neighbor said that you had not been there and those children had been there all day
No,
by themselves.
they weren't there by themselves all day. I was there all day with them.
No, they say you were driving up and down street with your then boyfriend. Court is calling 2024 CR 012173 State versus Estrella Hernandez de Jesus. Could I have parties announced for the record? State.
Rick Pena for the state of Texas.
Defense.
Help for the defense.
And are you Miss de Jesus?
Yes.
Counsel, have you received all discovery?
I believe I have, Your Honor.
And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. De Jesus, did you review the application for deferred adjudication or community supervision with your attorney? And did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor. So we're proceeding on count 1 of the indictment and we'll waive count 2.
No objection, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of abandoning or endangering a child with intent to return? That is a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine.
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes,
Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
She is, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I believe so.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes, Your Honor.
According to the plea, the state is proceeding on count 1. There's a $1,500 fine. State recommends deferred adjudication in the parenting class. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
That is the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, are there any such motions?
There are none, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 3 years, 150 hours of community service restitution, no contact with the complainants, the MRT, staff evaluation, and follow all recommendations. Did you understand those were recommendations from the state and the court does not have to
Here it comes, the pivotal moment, all the legal prep, the admonishments, the waivers, it all leads to this, her guilty plea. And remember, even though she's pleading guilty, deferred adjudication means she might avoid a conviction if she completes everything the court orders.
follow those recommendations.
Yes,
Then to the offenses charged in count 1, how do you plead? Guilty, not guilty, or no contest?
guilty.
State any evidence.
Yes, Your Honor. At this time, state offers into evidence State's Exhibit 1 with all attachments.
No objections from defense, Your Honor.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes,
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
yes,
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you've applied for deferred adjudication. Are we proceeding with sentencing?
With your permission, Judge, we would respectfully request to waive the PSI.
Anything you wish to say on behalf of your client?
If it pleases the court, first of all, regarding the $1,500 fine, we would ask the court to probate at least a portion, if not
I
all
will
of it.
probate the fine.
She is 22 years old and she does have these 2 young children. She is not receiving child support currently. Currently, she's been incarcerated for several months. The children have been placed by CPS with her aunt, Maribel Villegas. And as soon as she gets out, CPS has recommended some programs for her to do some services, which she has informed me that she is ready, willing, and more than willing and able to perform. So we've just addressed the recommendation by the DA of no contact with the 2 complainants, which are her children. She would like to have at least no harmful and injurious contact or possibly some supervised contact, whatever CPS recommends based on her progress with respect to their plan that they have. She does have a plan for employment once she gets out. That'd be to immediately get with some temporary services and agencies until she can find steady, regular employment. Her last such employment was with Toyota 2 years ago. She had to leave that job because of the commitments that she had with these 2 young children. She was unable to be at work all the time because she didn't have sufficient sitters for the children. Her aunt has stepped up, and that's who should be relying on once she gets out, Judge.
All right. So here's my question for you. Why were you not at home with your children on this day?
So what happened was I had a friend, she came to the house and she lived on the next block. She was going through it with her boyfriend. She wanted me to go help her pack a bag. She was scared that he was gonna hit her. So it was supposed to be a quick
So
thing.
here's my question. What were you planning on doing if her boyfriend were to show up?
Well, he was there, so she was scared of. She was scared that he was gonna break everything in the house and hurt her. So I was trying to help her. Like she.
So
felt
how
safe.
you helped her was you left let me make sure my math is right. The offense date It's 2024.
Help you out, Your Honor. The children were 3 years old and 1 year old at the time.
Yeah. So you decided, let me go help my friend with her crazy boyfriend and leave children alone who can't even take care of themselves in a house by themselves. And it wasn't just for 2 minutes, because the child who could talk said that they were thirsty and hungry. So tell me, where does, what is his name? Where does Mr. Adrian Ruiz play into all of this?
He was giving me a ride. He was down the street and he came with me. And we took the car. We went right there on San Fernando, which is on the next street.
No, because in the police report, people are saying that your car was driving up and down the street.
No, Your Honor, it's not my car. That was his car. I was at home all day.
The people who were in the car, which was you and this Adrian Ruiz person, were driving up and down the street. That's what it says. I spoke to the witnesses. They stated they were outside in the yard having a barbecue. They stated they had seen the above listed car driving up and down the street all day, but had not seen anyone in the apartment or any adults around the apartment from at least 7 p.m. Witness stated the party had been outside since 7 p.m. Witness stated they were listening to music and he heard something that sounded like screaming, so he turned down the music. Witness stated that they heard loud banging and screaming and looked to the incident location, and they saw victim one, and victim one is the 3-year-old, banging on the window and crying. They spoke to the victim. The victim said she was all alone. She was hungry and thirsty. And then the witness went to the front door to try to see if an adult was at home. And the witness stated the front door was wide open, but the screen door was locked. Witness called the victim to the front of the house and had the victim unlock the door. And that's when they arrived on the scene. So that's what I'm reading. So why are you driving up and down the street with Adrian Ruiz, and who is he to you? Is that your boyfriend? Who is he?
My ex-boyfriend now.
All right, so ex-boyfriend now? Was he your ex-boyfriend then?
No.
All right, so this is my problem. You were with this Adrian Ruiz. Is he the biological father of any of these children?
No.
So stop with the nonsense. What ended up happening is you are how old? You're 22. You're still acting as though you're out here in the streets single with no children. And what you have done is you put Adrian Ruiz Jr. How old is he?
He's 25.
He's 25. I guarantee you he doesn't want to be saddled down with 2 children. And you're riding up and down the street with this person while your 3-year-old and your other child who's younger than the 3-year-old are at home starving, don't have anything to drink or any food. Did you have food that day?
I have food, yes.
Did you drink that day?
Yes, so did
They didn't. Because guess what? These children, some of them drink milk, some may have water, some of them need their diapers changed. I guarantee you their diapers were not changed and their diapers were dirty because the neighbor said that you had not been there and those children had been there all day by themselves.
They weren't there by themselves all day. I was there all day with them.
No, they say you were driving up and down the street with your then boyfriend. And here's the thing, I understand things get dicey for young people. They're just like, you know what? I want to live my life. I'm settled with these 2 children. And I was putting my dreams and my hopes and my stars and my moon on the biological father of these children. He's not stepping up. I'm not receiving child support. And you know what? People should be thinking about that before they start having a lot of children. You understand?
Yeah.
And anything could have happened to these young children. Could have been instead of this nice person who was knocking on the door trying to take care of your children, could have been somebody who's a child molester and like, hey, this is a cute little baby. And then you would have been on the news screaming, somebody took my child, I don't know where they are, help me please. When it was because you were being a horrible mother. You understand?
I understand that.
I don't think you do. I think 2 years down the line, there's going to be another boyfriend. And the reason why I say that is because when mothers have child protective services cases, you know what people always tell them? Don't get involved with any more guys. Concentrate on getting a job, bettering yourself, and taking care of your children. And you know what always happened? During the middle of CPS, when children are being returned, next thing you know, mother has a new boyfriend, somebody from prison that oh, he's changed. He's a great guy. And in the meantime, you're putting your children's lives in danger. And children don't get to say, hey, you know what, Mom, you're making some stupid decisions out here, and it's going to impact me. People don't care because you're all in your feelings with this Adrian Ruiz Jr. guy. And guess what? If he were a good guy, you know what he would have said? I will come visit you at your house, but you cannot leave infants to take care of themselves. Instead, he didn't. And now you're telling me some lame story about you going to your friend's house to help her with a boyfriend that's being abusive when you don't even have your life in order. If her boyfriend were being abusive, you would have picked up the phone and called the police. Because what are you going to do? Are you going to get over there and fight a guy? No. You're just doing silly stuff and putting your child's life in danger. And I'm going to do this no contact order. If CPS wants her to have contact with her children, then what's going to end up happening is they're going to have to appear. They can appear by Zoom if they want to appear by Zoom and come to me with the child's ad litem and say why there should be a contact order. How far did you go in school?
I got my GED.
And what have you been doing with your life other than having children and driving up and down the street with Mr. Ruiz?
I was going to cosmetology school for a little bit, but I didn't have babysitters. So I stopped going and I started going to Toyota, Butex. That's when I was working there for a little bit. I got into this program called Goals. And I was doing that basically. I get monthly payments. I would get monthly payments from them. I had to make goals and I get incentives for completing goals.
Here's the thing. When people decide to have children, they should decide to have children and have plans for who is going to be the babysitter. You understand? There's a $1,500 fine that'll be probated. Proof of employment within 30 days of release. No employment as a home health care provider or with minors. TAP evaluation in custody. Follow recs. There should be regular reporting by Zoom or in person. Regular random UAs. There should be no contact with Adrian Ruiz Jr. If I could, if it were legal, I wouldn't let you have any contact with any adult male until you get your life in order and put your children first. But I'm not allowed to do that. So no contact with Adrian Ruiz or the complainants, CPS compliance, the MRT, 150 hours of community service restitution. I'm going to order parenting classes. Once parenting classes are complete, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice, and counsel if Child Protective Services gives her parenting classes, which they should, those will be acceptable. And it will be 4 years deferred adjudication. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful?
No, yeah.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing with CPS cases. If you're not going to put your children first, just let them know. And
He kidnapped her, then begged the court for forgiveness. But in a courtroom where words aren't enough, the victim's voice cuts through. He still tries to contact me. This isn't just a plea for probation. It's a fight for protection. What happens next will shake you.
The letter that the defendant wrote to the court.
yes,
I didn't know if you had a chance to read it.
yes, I have.
Thank you.
Thank you.
Hello, Judge Boyd.
Hello.
How are you today, ma'am?
Oh, I'm doing great. It's a beautiful Friday. Well, it's not Friday, it's Monday.
Monday.
Yes,
But
ma'am.
you know, the reason why I say it's a beautiful Friday, because when you're off on Friday, Friday becomes a Monday and a Monday. All right. According to you entered a plea to kidnapping of no contest on March 20th, 2023. According to the plea, punishment is to be assessed at 10 years in the prison. The state opposes your application. They're taking several cases into consideration. There's an affirmative finding of family violence. Have parties had a chance to review the PSI report? State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Any objections? State?
No objection.
Defense?
No, Your Honor.
State? Any witnesses?
I can have one more, Your Honor.
Defense? Any witnesses?
Other than the defendant, no.
All right. Would you like to, are there witnesses?
Yes, Your Honor.
Oh, you want to call her?
I thought it was for victim impact statement after sentencing.
We will be calling her as a witness.
I can't hear you, Mr. Rivera.
Yes. We will be calling her as a witness, Your Honor.
All right. Call your witness.
Your Honor, and I would object to her testifying to any that we would consider to be a victim impact statement that should be presented to the court after the judge sentences.
Okay. All right. Call your witness.
Your Honor, we call Jennifer Tovar.
All right, Ms. Tovar, if you come forward. Yeah, come up. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. I'm gonna need you to speak up so the court reporter can hear. State your name for the record.
Jennifer Tovar.
State.
Ms. Tovar, you are the victim in this case against Mr. Zaragoza. correct?
Yes, sir.
And you are aware that he has applied for deferred adjudication with probation.
I am.
And are you in what are your feelings if the defendant were to be granted probation?
Objection.
And what's your objection?
He's telling you what effect your decision will have on her. And we don't want her influencing.
All right, that'll be sustained.
Do you want the defendant to be released on probation?
Objection, Your Honor. It's the same thing.
Sustained.
Well, I'll ask the court to disregard, of course.
Oh, yes. It's disregarded.
Just 1 second, Your Honor. Ms. Tovar, on December 21st of 2021, can you tell the court what happened?
So I visited Ray to pick up Christmas money because me and the kids were living in Atascosa County due to a CPS case that we had for domestic violence.
Your Honor, I object because it's repetitive. Everything about that offense is in the police report, which was presented to the court as part of our plea package.
All right. So just so all parties are aware, I've read the stipulations in its entirety. I always reread those before sentencing, and I read them once I make a decision on whether there's sufficient evidence to find somebody guilty. And I've also thoroughly read the TAP evaluation. So you can ask your next question.
Yes. Ms. Tovar, have you had any contact with the defendant since these allegations?
Yeah, so he calls the house and speaks to myself and the kids. I guess when he can, because he doesn't have any reason.
Objection, non-responsive. She answered his question.
All right, that'll be overruled.
You can continue.
Oh, so he has to use, I guess, a pre-collect call that he has because he doesn't have any money on the account to call us.
Okay.
So, and I don't fund it anymore. I just did for a little while around Christmas time, but no, he's only when he gets a collect call he can call.
And Ms. Tovar, you currently have a protective order against the defendant?
I do.
And do you feel that is sufficient to keep you safe?
No.
And why is that?
Objection, Your Honor.
What is your objection?
She's commenting on what your decision will ultimately do to affect her and her children.
All right, that'll be overruled. You can answer the question.
No, I don't think so. It didn't in the first place. It didn't. Ray was still coming around and still calling.
And while these cases were pending, you did have a no contact order against the defendant, correct?
Right. But I was told that to let him talk to the kids. So even though we have a no contact order, and that's why I was taking calls so that he could talk to the kids. I didn't want anybody to say that I wasn't allowing it. Yeah, because they're not part of the protective order. It's just me.
Thank you. Nothing further on.
All right, defense.
No question.
All right, thank you. State, do you have another witness?
No other witnesses. Your Honor.
Defense.
It's the defendant himself.
All right, if you come forward, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Zaragoza Ray Jr.
All right, defense.
Thank you. Mr. Tovar, did you want to address the court with regard to why are you requesting her to give you probation?
Yes. I feel that given probation, I could complete probation. As you know, I haven't been in trouble before, Your Honor. This is the longest I've been in jail. I feel that I've made a mistake. And if you read the current note I wrote to you, Your Honor, it describes more of my feelings. I want to apologize to the court, and I want to apologize to my wife, who we've been together 11 years, 10 years. Been with the family 15 years. All I know is my family, Your Honor. And I'm asking for your leniency and your mercy, Your Honor, for probation classes so I can better myself.
Thank you.
All right, state, any questions?
Yes, Your Honor, briefly. Mr. Tovar,
Yes, sir.
in this case, you're charged with a violation of a bond of protective order, as well as a repeat violation of a bond of protective order, in addition to the kidnapping, correct?
I am?
He was.
I was.
And given that there was a no contact order protecting Miss Tovar from you, you violated those no contact orders.
That is wrong. She came to my home and moved in with me because she had no place to live. I wasn't going to leave my wife and my kids out on the street. So I did not violate it. She came to me, and that's how I violated her.
But you were made aware that any contact with Miss Tovar would be a violation of those bond conditions. Is that correct?
I was aware, but I was not going to leave my kids and my wife out in the street, sir.
In this kidnapping case, you did tie up Miss Tovar with duct tape. Is that correct?
No, that is incorrect.
And you said you've never been in trouble before, but you did have a case out of Atascosa County, Texas, for a violation of bond or protective order in that county as well. Isn't that correct?
That was for phone calls for talking to my children, which I had the right to do. And if you check the records, it says for electronic communication, I was allowed to talk to my kids.
And you did abscond during that case on February 9th of 2023. Is that correct?
Is that?
You just didn't do anything and you failed to report.
Okay. I was in jail.
Okay.
It's not that I failed to report. It's I couldn't go.
Okay.
I was in custody. I'm sorry. I said during that incident, I was in custody, so I couldn't go over there.
I have no further questions, Your Honor.
Any further questions?
No, Your Honor.
All right, any other witnesses?
No, Your Honor.
All right, the court will hear argument. State, you're opposed?
Yes, Your Honor. We're opposed to the defendant being granted probation. While you heard from the victim that she does not feel protected just by the no contact order, and that the fact that he was charged with a repeat violation of court order bond condition twice, which are being taken into consideration in this offense, Your Honor, shows that the defendant, whatever the allegations were, completely disregarded the court's order in telling him that he's not supposed to have any contact with the complainant.
But what about his saying that she came to live with him?
Your Honor, regardless of what the allegations are, if he knew that he had these charges pending.
No, I understand that, but isn't that mitigating the fact that she chose to go and live with him? Now, I understand financially there are issues, but a no contact order, of course, it's a document, it's on paper, and the defendant knows they're not to have contact with them. But what about his saying that he had a choice? Either his children were going to be on the street with her, or either she was going to come and live with him. But it doesn't appear in that situation, if it's truthful, he didn't go and have her come live with him. She decided to go live with him.
That is correct, Your Honor. And while it may be mitigating there, knowing that he did have that no contact order, there are other options for Mr. Tovar to be able to take care of his children without having contact with the complainant. He could have taken the children while Ms. Tovar went to go find another living arrangement.
Do you know she wanted him to take the children and leave without her children?
That I'm not aware of, Your Honor.
Okay.
But given that and given the allegations in this case, Your Honor, we don't feel that we do feel that the defendant is a danger to Ms. Tovar if he were to be granted probation. And so we'd ask that you deny the defendant's application to take it.
All right, defense.
Thank you, Your Honor. As you know from reading the pre-sentence report, my client doesn't have an extensive criminal history. These offenses, although serious, have really made him take a step back to reassess his life and how he lives his life and how he treats his family. And I think he's expressed rather eloquently in the letter that he tendered to the court. He's going to do whatever it takes to fix himself. He's even read the PSI where the recommendations on the CAPI valve that if granted probation, he should be placed in a program to help make sure he's no longer drinking excessive amounts of alcohol. And he wants to fix himself in that way. And he's been taking some classes in the jail since he's been in jail. It's been a couple of months now to help him control his demeanor, his anger, everything. He's trying to fix himself.
Okay. All right, this is what the court is going to do. The court is going to deny your application, find you guilty, sentence you to 9 years in the prison, give you credit for any time served, take in consideration 2022 CR 7416 2023 CR 1300, County Court Cause number 698311. There's an affirmative finding of family violence. There's a $1,500 fine, time and money to run concurrent, and there's to be no contact with Jennifer Tovar. All right, we can go off the record. You have to make better decisions in your life.
Yes, Your Honor. This is just a mistake, Your Honor. I wish.
Well, no, it was a choice, and it was a bad choice.
Yes, ma'am.
And here's the thing, I understand about protective orders.
Yes.
I understand that sometimes the person who the protective order is supposed to protect, they decide that they're going to go live with the person that there's a protective order against. And then there's an issue that happens, and then everybody calls the police, and here we are.
Yes.
So when you have a protective order, you are the person who are responsible. And if somebody wants to come live with you and there's a protective order in place, you need to say no. Do you understand?
I do now, Your Honor.
Well, I mean, you knew beforehand. You just decided, maybe we can work this out. Here's the thing. She doesn't want you anymore. That relationship is over. You can consider her on paper, unless y'all got a divorce, she's still your wife. But in reality, she's not your wife anymore. She does not want to be with you. Do you understand? Do not call her from the jail. Do not call her from the prison. Do not contact her. And if you want to see your children, and Ms. Burke does a lot of civil work, if you want to see your children, then that needs to be done through a third party, but it's not to be done through Ms.
As the judge announced a final verdict, probation is denied. 5 years in state prison. Joshua's body gave out. He collapsed the courtroom floor, overwhelmed by the weight of the sentence. His mother gasped from the gallery. Deputies rushed to help as silence fell across the room. The judge paused, watching solemnly, then said, "This isn't the end, Joshua, but what comes next is up to you."
Joshua and Zadua. All right, on this case, there's only a plea on one case. Is that correct?
I don't remember.
Okay.
I think so. I think they either PIC the other ones.
Is there a plea on two cases in this?
Yes.
Okay, just let me get the papers in order. All right, the court is calling 2024 CR 3794 and 2024 CR 006799, State versus Joshua and Zadua. Could I have parties announced? And are you Joshua and Zadua? All right, you entered a plea in each of these cause numbers. According to your plea bargain agreement in each case, punishment is to be assessed at a cap of 10 years in the prison. The state is opposed to your applications. These cases will run concurrently. The state will take in consideration 2024 CR 006796, 2024 CR 006798, 2024 CR 007768. Have both parties had a chance to review the PSI report? State?
Yes.
Defense?
Yes, sir.
Any objections to the PSI report? State? Defense?
One minor correction we saw in there, Judge, on the portion talking about criminal history. I think it indicated that he had a juvenile record. He does not have a juvenile record.
Oh,
I think somebody just marked yes when they meant to mark no, but I didn't see anything else that I saw that was problematic or objectionable.
all right. And then there was also a Tacoma screening completed and a TAP evaluation. Any objections to those documents? Defense?
No, Your Honor.
State? All right. Are there any witnesses? State, do you have any witnesses? All right. Defense, you may call your first witness. Hello. Oh, I'm doing okay. How are you doing this morning? Well, this afternoon. Yeah. Yes, I am. Could you raise your right? Are you going to swear in? Yeah. All right. Could you raise your right hand? Do you solemnly swear or affirm that testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand if you'll state your name for the record. All right. Thank you. Defense, you may proceed.
Hello, Maria. How are you? Just introduce yourself. You are Joshua's mother. Is that correct?
Yes.
They say you've known her whole life?
Yes, I do.
So, ma'am, where is Joshua living now?
He resides with me, 279 years.
And how long has he been living with you? So about 4 or 5 months?
4 months, 5 months. 4 or 5 months.
How are things going at home with Joshua?
Good.
Does he help around the house?
Yes.
Ma'am, you understand what we're here for today, is that correct? And some serious offenses, some serious crimes that we're asking for probation.
Yeah.
Is it your desire to that Joshua gets probation?
Yes.
Do you think Joshua is somebody that needs help?
I know sometimes I get, but he's good.
Has he been pretty good with you?
Yeah, I'm sorry.
If you know, Joshua, working or up till recently, was he working?
He was working with
Okay. Since he's been living with you, I know he's in jail, awaiting trial in these cases and everything. Have you had any problems with him at your house?
No.
Thank you, Your Honor. We'll pass witness.
Any questions?
No. Go back into jail. Before he went to prison, yes.
Oh, I just have a few questions. Hi. I just have a few questions because I'm always interested in trying to perhaps figure out why people do what they do. That way it can help me with some determination sometime. So, what do you think he went wrong in his life? Why is he doing these things?
I'm gonna be honest.
Mhm.
And
All right. And how old is your son now?
his son is good.
No, how old is he? All right. All right. So this is what I want to tell you. I do appreciate your testimony, and just know that your testimony was well received. So whatever decision I make in this case, I don't want you to feel guilty about it, that maybe you should have said something else, or maybe you could have done something else. Because at some point in time, you know, children are adults, right? So yeah.
You know, I'm expecting positive. I'm not expecting negative from all of this, and I want him to be better.
Okay.
From
All right. Thank you so much for coming down. All right. Well, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand. State your name for the record. All right. Defense?
Joshua, we just heard a little bit from your mom about you. You know what we're here on today, correct? There's some pretty serious offenses in front of this court, some felonies, and you're facing up to a decade's worth of conviction, right? Okay. Let's start in the past. I'm not trying to hide anything. You went to prison in the past. Is that correct? What'd you go to prison for? Sorry. And anything else? Or? Okay. And just to clarify, were you revoked from the drug probation at the same time you were sentenced to prison on the burglary? Okay. How long did you go to prison for? 2 years. Did you do the full term? Okay. When did you get out of prison? 22. So Joshua, since you got out of prison, have you used drugs or narcotics of any type? What were your drugs of choice, sir? Amphetamines? When was the last time you used amphetamines? Well, let me rephrase it this way. When did you most recently get out of Fairfax jail? Last year, 2024? In that time, from December 2024 to today, almost at the end of March 2025, have you used drugs? Your drug test today, would you be positive or negative? Sorry, no pun intended, but if you're positive, you would be negative? Okay. Joshua, I want you to tell the court why you think you're deserving of probation in this case. Are you working right now? When's the last time you were working? And you got locked up. How long were you locked up? Roughly, you know? 9 months. 9 months. Okay. So my apologies. So you're locked up for a significant amount of time. If you are fortunate enough to get probation, Joshua, you understand that this judge could, this court could order you to inpatient rehabilitation. Would you be accepting it if that was one of the options that a judge would play? And so you're willing to accept treatment? Joshua, is there anything else you want to tell the court or myself or anyone before I hand you over the question about the DA's office? All right, now we'll pass this witness.
State?
You said you have drugs and treatment alcohol. You say in your pre-sentence investigation that they questioned you about the setup. You say the police like attacked me. I was trying to get off the bus. I am a victim. That's what you said. Is that what you believe?
All right. I'll have a few questions if there are no objections.
No objections.
All right. So did you have a chance to read page 6 of the PSI report? Did you have a chance to read page 6 of the PSI report? All right.
You went over the PSI. Maybe we need to see what page.
Oh, just 1 second.
I'm sorry, Judge.
I think I may have it. Oh, I have an extra copy.
Your Honor, I did go over this with them. This is, I believe, a statement by the Metropolitan Police Officer.
Okay. Have you had a chance to, could you read that to yourself? So you read that. How do you feel about that? But I mean, when you read that, do you hear what he's, I mean, are you internalizing what he's saying? Yeah, he just sounds as though he's given up. He's like, I have been doing this for 30 years. My job here is done. He's not going back. Do you think he would feel that way if this had not happened to him? Have you thought about that? Have you thought about his injuries? What injuries did he have? All right, you say they were trying to arrest you. How were they trying to arrest you? And so when you were trying to step off the bus and you're saying that they didn't tell you what you were arrested for, what did you do? All right, so what did you do? And how did you do that? Not, I guess, I mean, you were there, I wasn't there, your attorney wasn't there, the state wasn't there. So how did you try to do that? So you're saying his injuries because he stumbled and that had nothing to do with you. And if it didn't have anything to do with you, let me know. I am not holding it against you. I just am trying to figure out what your thoughts were on that day. Well, you're saying he stumbled. How did he stumble? Okay. All right. Any other questions, defense?
It's found on this. On the bus, there was two officers, correct? If you remember, Josh, did y'all all end up on the ground at some point? Were you inside the bus or outside the bus? It was outside the bus, so it's like on the sidewalk of the pavement or something? Okay. Did they try to arrest you on the bus or off the bus? On the bus, outside the bus. How long did all this happen from the point where they tried to arrest you to the point where you were tased? If you had to guess. Thank you. No further questions, Your Honor.
Any follow-up, state?
No, Your Honor.
All right. Any other witnesses?
Nothing further, defense, Your Honor. Just
All right. The court will hear argument. All right. Defense.
Your Honor, the defense is asking for probation, either deferred or even straight probation for the conviction in this matter. Even if that involves inpatient treatment, status or safety up front, we're not opposed to it, Your Honor. Mr. Enzaldua has a history, and it's unfortunate that we're here today again. I know you don't like to hear the word that mistakes were made and everything else. These are very unfortunate choices. Your Honor, I believe he is taking responsibility for what has happened. The court has the discretion, the sole discretion as on what needs to happen here. He's facing up to the decade in prison. It's a very long time. Person to follow. But I would suggest that he would be better served, the community would be better served if he was placed on probation. TC is a place to go. There are certain cases that are warranted for it. However, in this particular case, Judge, I think it's clear there's a drug issue, drinking issue, everything else. In the short time he's been out, he's done okay. I think he will be successful on probation if he's granted. For those reasons, Your Honor, we're asking place him on probation. The court sees fit to order him to inpatient treatment, but Your Honor, we're begging, pleading not to send him to prison.
Do you think you need inpatient treatment? Well, no, I mean, when you were talking before, you had requested outpatient treatment.
I've never had it before, so.
All right. I don't think that probation is appropriate in this case, so I'm not going to grant probation. I'm going to find you guilty in each cause number. I'll hear any argument to time.
Yes, Your Honor. I know the state's asking for 10 years for the judge. We have a wide range, anywhere from 2 years all the way up to 10 years. Your Honor, we would ask on the lower end that no more than 5 years. Again, I think Mr. Enzaldua is somebody that suffers with demons. He would benefit from treatment. We understand where the court's coming from by not granting probation. But Judge, we're open, begging that the court's consider if that's something less than 10 years. We would suggest a sentence of 5 years or less.
And state. All right. So I'm looking at your previous history, which is a part of the PSI. You have a previous resisting arrest, search, or transportation. On that case, you were given deferred adjudication. You were revoked. Then you have a driving while intoxicated. You were given jail time. You have an evading arrest, detention, jail time. All right. This is what the court is going to do. The court is going to sentence you to 8 years in prison in each cause number. They will run concurrently. Take in consideration 2024 CR 006796, 2024 CR 006798, 2024 CR 007768, I'm going to order no contact with the complainants and restitution in each cause number with the complainant. Did you review trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do y'all need help? You got it? Thank you, counsel.
Want to see if we can recall it for next Friday so she can go back to the hospital. And then I anticipate next Friday it'll be a plea.
I can put it for Thursday.
That should work.
All right, Ms. Ferguson, recall this for the May 29th, and that's for disposition.
Just go ahead and see if I can find you.
All right, who is here on Fernando Alvarado? Sometimes I don't have the cases, and other people are standing there looking.
I figured I would check.
Oh,
Thank you,
God,
Judge.
okay. All right, let me just put this in the system. And what page is Medellin on, please? Oh, I found it. All right, the court is calling 2025 CR 003132 State versus Fernando Alvarado. Can I have parties now?
Andrew Harrison.
Jasmine Olguin for Mr. Alvarado.
And are you Mr. Alvarado? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alvarado, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented? Mr. Alvarado, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your
Did you understand if the court were to grant your application for deferred? Oh, that's yours.
Oh, thank you, Judge.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is recommending deferred adjudication. They're taking in consideration JN number 2170834 and 2170835. Did you understand that to be the plea? Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yeah.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yeah.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yeah.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
Yeah.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objection.
Did you review, state, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yep.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
All right. So how often have you used in the past?
In the past, it was only for a few months.
All right. And then are you still with the people who are listed as complainants in this case?
No.
State, okay. And are you employed?
I have a small business.
All right. What do you do?
I have a mobile bartender.
I'm sorry?
Mobile bartender.
All right. And do you have any children?
I have a daughter.
This is what the court will do. Probation, are you ready? 4 years deferred adjudication, Taking consideration JN 2170834, 2170835, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations. If you're drug tested today, what are the results going to be? All right, you're going to get drug tested today. You understand? There's going to be 60 sober meetings in 60 days, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the following persons: Jennifer Lynn Stanley, Stanley, Christopher Martinez, and there's to be a mental health evaluation out of custody, 100 hours of community service restitution, field visits one time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just ability to be able to work.
Oh, you'll be able to work.
I'm in the.
All right, but here's the thing, while you're on probation, you're not allowed to drink alcohol. You understand? All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record in this court. In order to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel that you're about to drink or you're about to backslide, call probation, let them know. They're going to give you help. If you feel that they're not addressing your issues, you can always come back to court. All right, good luck to you. Just remain in the court until you receive the documents. And counsel, if you'll make sure that they've done the dismissals for the JN number.
Yes, Your Honor. Thank you. Have a nice day.
Thank you, you too. Okay, thank you. Just give me a moment. All right, just one second. Just one second. Let me just, all right. Mr. Corpus.
Yes, Your Honor.
All right, what are we here for?
Judge, we're here for probation, has requested that Mr. Corpus be released from his GPS monitoring. He was placed on it for an indeterminate time when he went on probation. He's been on it for almost 14 months. And probation has described him as, I'll let probation speak.
Judge, we have absolutely no concerns with Mr. Corpus. He has had no violations. He reports when he's supposed to report, no violations with his GPS monitor and or with his UAs, Judge.
All right.
And he's doing the classes as he's needed to do and everything, Judge.
All right. And my understanding, he's completed the family violence.
Judge, I don't have the court summary in
Oh,
front of
I'm
me.
sorry. I have it. I have that he completed lifetime recovery, batterers intervention and prevention program. All right. You want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
My name is Nicholas Isaiah Corpus.
All right. What did you learn from the batterers intervention and prevention program?
Just to keep your hands to yourself.
That's what I tell everybody. Keep your hands to yourself, right? So how do you spend your days?
I work Monday through Saturday for ATS Transportation Company. And then Sundays, I do side jobs, painting cars, motorcycles, boats. Pretty much just work all the time. It's kind of hard for me to keep money in my pocket.
All right. So you know that you're not allowed to have any contact with the complainant?
Yes, Your Honor.
All right. State, were you able to contact the complainant?
She does have significant state concerns still, since yes, monitoring was placed. She can't confirm, but the person that she knows is the friend of this man viewed her profile on LinkedIn. Additionally, on April the 24th, the defendant picked up what is currently an at-large misdemeanor for two attempted contacts of the victim by phone and then Facebook messaging.
Judge, I can't have my client make any statements about that allegation. I can tell you that I've had a lot of contact with Mr. Corpus. I don't believe the allegation. At the very crux of this, before we even did the plea, he didn't want anything to do with her. I don't believe for a second that he's reached out to her. And today is the first time I've had any information given to me about these charges. There's no warrant at this time.
Okay, so this is what the court is going to do. The court was really inclined to lift the GPS, but I want you to have a chance to see what they're talking about with this. What they're saying is an at-large violation of protective order. So how much time do you think you need to look in that and state, when can you give the information to the defense? All right, so then what we'll do.
And Your Honor, if I may, no report's been made to probation. So she knows he's on probation. She didn't ever call probation to make any complaints.
Okay. All right. So here's the thing. And I want you to understand where I'm coming from. When people are on probation, I have to make sure that the public is protected, right?
Yes.
Now, I'm not saying that the violation of the protective order that they're saying is in place that you violated. I don't know. I have zero information. Right now, I have as much information as your attorney has. All I have is this is what the state has said. I'm not taking what they said as true. Before I release you from GPS, I want to get some more information about that. And you'll need to have the complainant come in on this next date that I'm giving you. And defense, if you'll let me know what date is good for you and your client works, your client can appear by Zoom. So
Yes, Your Honor. And Judge, I think, is he on tracking only, I believe?
if he's not on tracking only, I'm going to put him on tracking only and state you'll know where he's located.
Judge, in addition to that, one of the big concerns is this is a big financial pressure on him. He also helps his mom. I have a letter here that she's written. He's not able to help her with as much as she needs because of all of his costs. And so, as you know, the GPS is very expensive. Is it possible for the court to waive those fees?
I will tell you this, I will ask that fees be waived, and you know what they're going to tell me? It's a third-party contract. I can't waive the fees, but I'll put in there to waive or defer fees. And if he's not on tracking only, I'll put him on tracking only because with
Yes, but are you on tracking?
How do I know what is tracking on you?
tracking is you can go wherever you want to go, but you keep the GPS on and they'll know where you are.
Yeah, I also have a time.
Well, on this one, you won't have a time limit. The GPS device will be able to report where you are. So if you're anywhere near the complainant, the GPS is going to know. You understand?
I think that's what I'm on.
All right. Well, just to make sure, it's going to be tracking only. And counsel, how much time do you need? The state said they'll print out this information for you. When do you want it called back?
Well, Judge, I can look over it today. I'm obviously not retained on that case yet, but I can look over it today. I mean, all we're going to have are allegations. I don't know if they have any discovery that they can also provide without me being on the case yet.
As of right now.
All right, so this is what I can do. Your client, as I said, can appear by Zoom. I can actually recall this fact for May 29th. And if you all are not able to provide information to the court on May 29th, then we'll do it on a different day if defense, that's not enough time for you.
I can do it on May 29th, Judge.
All right, so we'll come back on May 29th and state if you wish for the court to continue to have him on GPS, I'll need witnesses.
Yes, we'll have.
Thank you, Judge.
All right, once you sign the reset form, you're excused.